Hey folks, Bob Mason here, and I just want to discuss very briefly something about the North Carolina Advanced Directive forms. For our purposes, there are actually two different forms. There's an advanced directive for a natural death, also known as the living will, and then we have a healthcare power of attorney. A healthcare power of attorney. They're two different forms and they do two different things. An advanced directive or a living will, I don't know if I got that in the camera right, is a document in which someone, the principal, is telling the healthcare providers what they want done or not want done at certain points, usually as they approach a terminal state, what they want done or not want done medically. There is a section in the Advanced Directive form, Section 6, if you want to look at one, that says that this will override any decision a healthcare agent may make. We'll talk about that in just a moment. Or the healthcare agents may override this. Well, personally, I thought, why do you fool with an advanced directive for a natural death if you're saying that the healthcare decision, the healthcare agent's decision, will override this? Whatever, maybe you think it's useful to provide some comfort for your healthcare agent and family member as to what you may or may not want done at getting close to the time of your death. Now, what I really want to talk about, and oh, by the way, most of my clients don't bother doing a living will, and that's fine. There is no legal requirement that you have a living will. So most do without it once they decide that if they have some family members or a trusted loved one that will make the kinds of healthcare decisions that the principal would want made, or the principal trusts them to be able to do that, why bother with the living will when you can just rely on your healthcare agent? And again, there's no requirement that you have a living will. Now, let me point out just something very quickly about the healthcare power of attorney, and then we'll wrap up this little pointer. I don't want these videos to get too long. But if you look at, let's see here, the second page of the healthcare power of attorney form, I blocked out the names to protect the guilty. You name your healthcare agents and you list their contact information so they can be found. Then under 2, you can put, let me get it over here, you can put effectiveness appointment, which my clients always leave blank. You don't want to say my healthcare power of attorney will become effective 6 months from now and then be revoked 8 months from now. Just sign the darn thing, because it doesn't take effect until the doctors say that you are unable to make or communicate your own healthcare decisions. The next page is what I want to point out. Section 4 of the healthcare power of attorney has a couple of elements. Generally, what you're doing in Section 4, let's try and get it over here, is Section 4, if you look at it, you are giving your healthcare agent full power and authority to make healthcare decisions for you. Full power and authority, with one exception. Up here, it says, subject to any restrictions set forth in Section 5 below, I give my healthcare agent full power and authority to make decisions. Subject to any restrictions that I have put in Section 5. Section 5 of your healthcare power of attorney, if you look at it, is where you start in with all these decisions that you get to make regarding, well, the pages are stuck together. You've seen these regarding where you get to initial, regarding all these different things that you want done or not want done. And I have some clients agonize over making these sorts of elections. But you've got to understand that in this Section 5, all you're doing is saying that you are restricting your healthcare agent's full power and authority that you've given in Section 4. Section 4 says, subject to any restrictions in Section 5. I give full power and authority. The point being, if you've got a healthcare agent that you love, respect, and knows has the emotional stability to make the kinds of decisions that you would want made when the going gets rough medically, then why restrict it in Section 5? Once most of my clients understand that, what they do is just appoint the healthcare agent under Section, I forget, 1 or 2. They don't put any restrictions on the effective date. They give them full power and authority under Section 4, leave Section 5 blank, and then basically go ahead and execute the document. And if they've got that kind of soldier willing to work for them, they don't even bother with the living will. I'll be interested in your comments because those are simply my opinions.